The Supreme Court of India's recent judgment overturning a conviction under Section 353 of the Indian Penal Code, IPC, is poised to have far-reaching implications on how cases involving resistance to arrest are interpreted. This case highlights the crucial legal principle that mere resistance or an attempt to evade arrest does not automatically equate to the use of criminal force against a public servant, especially when the intent to cause harm is absent. The case involved a man convicted under Section 353 IPC, which deals with assault or criminal force to deter a public servant from discharging their duty. The conviction was based on the man's actions during a police sting operation, where he allegedly resisted arrest. The Madhya Pradesh High Court had upheld the conviction, leading to an appeal in the Supreme Court. In a thorough examination of the facts, the Supreme Court found no evidence of intent to harm the police officers involved. The court emphasized that the resistance shown by the appellant, pushing and jostling to escape, was a natural reaction to being apprehended, rather than an intentional use of force meant to deter the officers from performing their duty. This judgment underscores the importance of mens rea, or the intention behind an act, in determining criminal liability under Section 353 IPC. The court's decision clarifies that for a conviction under this section, the prosecution must prove that the accused intended to use force against a public servant. The mere act of resistance without a clear intent to harm or obstruct does not fulfill the legal requirements of Section 353. The implications of this ruling extend beyond the specifics of the case. It sets a precedent that could reshape the legal approach to cases where individuals resist arrest, particularly in situations where police officers might sustain injuries during the process. The ruling reinforces the idea that intent, or mens rea, is a critical component in establishing criminal liability. If the intent to cause harm is absent, as in this case, Section 353 IPC cannot be invoked merely because a police officer is hurt in the process. This case refers to Mahendra Kumar Sonker v. the State of Madhya Pradesh. Criminal Appeal, number 520 of 2022 Supreme Court. This landmark judgment is likely to influence future cases involving police arrests, where the distinction between natural resistance and criminal force becomes pivotal. By reaffirming the necessity of proving intent, the Supreme Court has set a new standard for the application of Section 353 IPC, ensuring that the law is applied justly and in accordance with the fundamental principles of criminal jurisprudence. Friends, if you found this update insightful, don't forget to like, share, and subscribe to Kanoonplus Live for more in-depth legal analysis and updates.